I think so. I need to put my first slide on. I get them done. Let's go. Yeah. Yeah, no, students coming here. So the camera will be on me, but I'm only seeing my slides. I'm not seeing myself, right? Yes. Bert? Okay. Video window to the side. Take share the slide, you will see. Oh, I can't stand with comfort. So nice to meet you. Good.
Ready?
Sorry, I can't stand. Forgive me. Good to meet you.
Me.
Good morning, everyone. Good morning, everyone, and welcome to the Norman Manley Law School Legal Aid Clinics Fair. It is my pleasure to welcome everyone that's in our viewing listenership this morning and located here on the premises at 18 Gibraltar Hall Road. We are looking forward to a week of activities, and I'm sure that you'll be very interested in what we have planned to share with you from today onward. Today we begin by looking at the Road Traffic Act, and we will be hearing from a number of presenters. Lined up for us, we have Mr. Bert Samuels this morning, who will be treating with the matter of stop and search should you allow the police to stop and search your vehicle. Later on today, we'll be having Dr. Garth Little, and he'll be looking at the changes to the Road Traffic Act. Now, today marks the start of a week of activities, and I know that you will be enjoying sharing with us as we look at expungement of criminal records, habeas corpus applications, the mentally ill before the law, children, and domestic violence matters. So stay tuned right here on this YouTube channel for the rest of the week. Now, this is a part of our 50th anniversary celebrations, and so I'm going to hand over now to our principal, Ms. Carolina, who will be taking us through the week of activities. On the camera.
Morning all. Let me join the director in welcoming you to the Legal Aid Fair this year and to all the events that will be held this week. Are part of the law school's job for public education and public legal advice is part of the mandate, and of course the Legal Aid Clinic is the frontline operation for that. In addition to that, as the director has pointed out, we are in the process of what we call 50 weeks to 50. In 2023, September, the law school will celebrate 50 years of the Council of Legal Education operating legal education, vocational legal education in the Caribbean. And that's a signal event and a signal milestone. And we feel it's worthy of celebrating. In fact, there's a lot of celebration on the university campus this year. The campus itself will be UEMONA celebrating 75 years as we celebrate 50 years. We ask you to keep informed by subscribing to the Norman Manley Law School's YouTube channel, where as part of the 50 weeks to 50 years, we have been featuring graduates from every class for the last 50 years. I think we're currently at about 1984 or 5. And so you're being asked to vote for graduates from your class to be the featured graduate for the year. And we are also putting on a number of CLPD activities. We will also have really grand celebrations from September 23 through to August 24, which is an entire year of celebrations of the 50th, as well as continuing our community activities through the Legal Aid Clinic. So once again, I want to thank the director for this week of activities where there's a lot of partnerships with a number of agencies and to ensure that the public is kept informed and given legal advice. Thank you very much, and stay tuned to our YouTube channel and otherwise.
Good morning, everyone, and welcome again to the Legal Aid Fair. My name is Dion Cruikshank, and I will now be introducing our esteemed legal counsel, Mr. Bert Samuels, who will be our next presenter. Next, and our first presenter for the Legal Aid Fair, Bert Samuels has practiced law in Jamaica for more than 40 years and is currently partner and head of litigation with the firm Knight, Jr. and Samuels. His career began with graduating from the University of the West Indies, Norman Manley Law School, and his areas of practice have centered on industrial relations, civil and criminal litigation. He has sat for 5 years on the disciplinary committee of the General Legal Council of Jamaica and is a frequent presenter for continuing legal education seminars with that body. A passionate Pan-Africanist, he continues to advocate for changes to inherited colonial laws with a view to further liberating a post-slavery Jamaica. After 12 years as a member, he now serves as deputy chairman of the Jamaica National Council on Reparation and leads their legal working group. In addition to his legal work, Bert is also a recognized writer and social commentator. His play, The Trial of Governor Eyre, placed the former British appointed governor on trial for overseeing colonial violence and eventual mass murder in 1865 and was nominated in multiple categories for the Actor Boy Awards. He recently contributed a chapter to the upcoming publication, Time for Reparation. Published by Harvard University, in which he outlines a strong case for Jamaica's claim. His 2021 and latest appointment is that of one of the 12 commissioners who presided over the International Commission of Inquiry on Systemic Racist Police Violence against People of African Descent in the United States. Bert has also frequently written extensively for Jamaica's leading newspapers and is frequently interviewed by media houses on issues examining law, history, social justice, and reparation. And I now introduce Mr. Bert Samuels, who will be our first presentation this morning. Over to you, Mr. Samuels.
Yes, greetings. It's good to be back in the Legal Aid Clinic. I was here some 45 years ago, and it's timely that I return to share the little I've gathered in the last 43 years of practice. Yes, Ms. Shank has read the things that I am supposed to be or have done. The one that strikes some similarity to the presentation I'm doing now is after George Floyd's encounter with the police in the United States, the Black Lawyers Association in America brought the United States to the United Nations for them to say that African Americans were being discriminated as a racial minority. The United States and its colleagues hit that attempt to have United Nations rule on the matter, and hence the lawyers decided to draw on lawyers outside of the United States to deal with the police discrimination and murder of African American men, particularly in motor vehicles. So unarmed African American men are stopped in the United States for infringements, traffic infringements, and they end up being killed by the police. I'm happy that that's not as pervasive as it is in the United States, but what is very troubling is what the citizens do when the police wave you down on the road. And therefore, the question that has been posed for me to address is, what are your rights when the police should stop you? I'm having a challenge with my slides here, but I know it will be fixed shortly. I want to go to my first slide, and I'm being assisted. Thanks for your patience. Okay. Here we go. The question asked is, should you allow the police to search your vehicle? Let me repeat, should you allow the police to search your vehicle? Very interesting topic that I've been asked to address, because in a real way, do we have a choice when they say they want to search our vehicles? I'm not sure if the average Jamaican citizen think that they have a choice. So that I think that this question is more likely to arise in the civil courts after you have been stopped to challenge whether that stop is constitutional or legal. So let me start by saying, because I think I'm addressing mostly law students, and I want to make a critique of the education that we have received. And there's a tendency for lawyers who live in the jurisdictions where the Constitution is supreme, such as Jamaica, but who are schooled in English law, to give insufficient attention and application to their respective constitutions. Nowhere in the English-speaking Caribbean does there exist the supremacy of Parliament. This means the starting point for any discussion of our rights regarding being searched must be Constitution. That discussion will also include the restrictions imposed on Parliament not to pass any law which tramples on our rights. That is why the Constitution is supreme and not our Parliament. We must also be constantly mindful of Lord Diplock's caution in Hinds and the Queen, that most important constitutional case, which I commend to all lawyers, that 1976 One All England report. And Lord Diplock in that case made it clear that a breach of constitutional restriction is not excused by the good intentions with which the legislative power has been exceeded by a particular law. Let me repeat. A breach of constitutional restriction is not excused by the good intentions of our Parliament where it exceeds a particular law. Lord Diplock's pronouncement makes adherence to the Constitution impatient of any justification from a departure from its restrictions on laws which offends our rights. For example, it is a notorious fact that gunmen travel in motor cars to carry out their crime of drive-by shootings and also to transport weapons from one place to another. We are constantly tempted to give the police a free hand to randomly search the vehicles of citizens to remove these guns from the street. In fact, in the recent case of Hemans, the court was very mindful of this temptation and opined at paragraph 15 as follows. That's Justice Batts. He said, in closing, this court is not unmindful of the high level of crime and the difficult circumstances in which the security forces are asked to operate. However, experience in this and other countries tells us that the fight against crime will be lost if in the course of that fight, war is declared on citizens of the country. That is one important reason why the rights of all citizens must be respected as the police carry out their very challenging duties. The Charter of Fundamental Rights and Freedoms at section 13(3)(j)(I) guarantees to us protection from search of the person and property, so that our vehicle, which is our property, the Constitution protects us from the search of our vehicles. Having regard to the fact that the police is an arm or organ of the state, section 13(3)(b) is also relevant and dictates that the police shall not, and I quote, take any action which abrogates, abridges, or infringes your right not to have your person or property searched. So we have the right not to be searched, and it tells that the state should not indulge itself in a breach of our rights not to be searched. The learned judge, being aware of the culture of random searches, and that is Justice Batts in the Heman's case, that it was unconstitutional, asked that a copy of his judgment in the Heman's case be sent to the Registrar of the Supreme Court, to the Commissioner of Police, and to the Commission of Indicom to guide both serving members of the force and those at training school, so that the taxpayers who are ultimately forced to pay these hefty awards for illegal searches may be relieved of that burden. Let's go outside of the Constitution now and go to the law that dictates what police can and cannot do. And therefore, we have to look at Section 13 of the Constabulary Force Act. That law, Section 13, in part, declares that the police are able to detect crime and to apprehend or summon persons found committing any offense or whom they may reasonably suspect. And those are the operative words. The police who they reasonably suspect of having committed any offense. That is the litmus test, whether the search is legitimate or unlawful. The stop and search, which I'm now addressing, does not concern anyone being found committing an offense, because it's clear, if you're found committing an offense, then the question does not arise whether the officer entertains a reasonable suspicion, but rather someone who is suspected of having committed or about to commit an offense. So by way of an example, gunmen having fired gunshots from a motor vehicle and having been apprehended by the police, there's no question that the police have a right to search the motor vehicle. This is so because, simply put, the occupants of that motor car would have been found committing an offense. What we are therefore discussing here is the requirement under Section 13 of the Constabulary Force Act that the police officer must form a view which leads him to reasonably suspecting that the motor car or that the occupants of the motor car have committed an offense. In short, to make a search legitimate, it must be proven that the police had reasonable suspicion that an offense is being or is likely to be committed. The Oxford Dictionary defines a search as to look through or go over thoroughly to find something. Really, a fishing exercise. A lawful search carried out by the police cannot be carried out in the absence of reasonable suspicion. Let me repeat. A lawful search carried out by the police cannot be carried out in the absence of reasonable suspicion. Hence, a fishing exercise which is not intelligence-driven to find anything concealed is prohibited. And let me stop here to say, when the police say they are carrying out a spot check is a fishing exercise. A motor vehicle who is stopped because of a spot check is an illegal search. You're hoping, without having any suspicion about the car or its occupants, to find something. The law does not permit that. So the question that I've been asked to address, should you allow the police to search your vehicle? It would be naive of me and simple-minded to assume that police officers who stop a citizen's vehicle will ask, "May I have your permission to search your vehicle?" That's preposterous. And so that on a dark night on a poorly lit road, a citizen who is asked by armed police officers and soldiers for a search may totally resist the temptation to inquire along the he-man's lines. That is, may I ask, what is your reasonable suspicion for making this request? We have to keep it real. Paragraph 56 of the he-man's decision, the judge found that the police at no time felt it necessary to give a lawful reason, that is before or during the case. And this case was put forward by lawyers from the Attorney General's office. The judge was critical. He says, at no time during the case, the police felt obliged to give the necessary lawful reason for stopping he-man's vehicle. And that's a position, stopping the vehicle. And we will see later that when you're stopped by the police, you are being restricted in your right under the Constitution to the freedom of movement. So there's a stopping. No lawful reason was given why he-man's vehicle was the subject of a search. And thirdly, no lawful reason was given by the police why they requested he-man's car documents. A search commences with the stopping of a vehicle. But the police and the citizen must be mindful of the fact that we are guaranteed by section 13(3)(f), as in fish, to the right to freedom of movement. That is to say, the right of every citizen of Jamaica to enter Jamaica, and secondly, of every citizen of Jamaica lawfully in Jamaica to move around freely throughout Jamaica. And I should not have said every citizen of Jamaica. Every human being in Jamaica has the right to move around freely throughout Jamaica. So that when a police waves you down, he's actually carrying out a restriction on your section 13(3)(f) rights. That is the right to freedom of movement. It therefore means the stopping of your vehicle must be reasonable, come out of reasonable suspicion. My first comment here is there's a duty on members of the security forces to dress appropriately with regulation numbers clearly exposed and be so that it could be easily identified by a citizen. The reason for this is obvious. At the end of our interactions with the police, we should be able to have the name, and if there is a refusal, at least the regulation number of security forces with whom we interacted. I pause here to say, many times when clients come to see us at our chambers, the police have refused to give their names. They do not, some of them have regulation numbers affixed, and therefore when they come to seek constitutional redress, we do not have the name of the Crown servant. Of course, we know as lawyers, we can plead that the person was dressed in uniform, was in a police marked vehicle, and therefore ask the court to infer that this phantom, this unknown person, was in fact a member of the constabulary force. The security forces' powers to stop us and restrict our rights to freedom of movement must be preceded by reasonable suspicion. This is so important, it merits a repeat. The security forces' powers to stop us and restrict our rights to freedom of movement must be preceded by reasonable suspicion. So the stopping in itself becomes a legal issue. This means the habit of stopping high-end motor vehicles for spot checks is an affront to the law. Where and when the police were allowed to spot checks is not known. The case of Hemans frowns upon this commonplace net fishing exercise. The police seems wedded to. Immediately following the subsection guaranteeing our right against arbitrary search, section 13(ji) are subsections 2 and 3. These sections give us protection of private life and protection, and I quote, protection, privacy of other property and communication. So a police officer who is searching my car and sees my diary, notebook, or phone and seeks to search any of them is in violation of my right to privacy of property and communication. Now, because most of my listeners are attorneys, I want you to guard your right to the privacy of communication. It does not only relate to your boyfriend or girlfriend or spouse who may want to search your phone, which has information about your clients, but it also relates to state officials, including the police. Let no police officer take your phone up as counsel or your files on the back of your car seat and begin to go through them. That's going to be problems. So that in the matter of Hugh Thompson, with whom I graduated from this noble institution, an attorney, a case in which I represented Mr. Thompson as attorney at law, we claimed and successfully received an award of damages for a breach of his right to protection of communication. Mr. Thompson was in his office when police officers invaded it. There were letters written to and by his clients when his law office was searched and files removed by the security forces. It is not inconceivable that the said principles would apply where these files are in counsel's motor vehicle, not just your chambers. Neither should we be unmindful of the fact that this protection is not for lawyers only, but also other citizens whose communication, be it in soft or hard copy, is invaded by the police without reasonable and probable cause. Let me hasten to say here, the police can entertain no reasonable and probable cause for communication belonging to counsel, because that right, lawyer-client privilege, is absolute. And the case of Hugh Thompson and others in the Court of Appeal has established that the right to communication between lawyer and client, that right is absolute. They had one exception where you must lift that right as counsel. Of course, the law gives absolute protection for lawyers and client communication, save and except in disciplinary matters before the general legal counsel. So the general legal counsel can order an attorney to bring correspondence between himself and his client or between others other than his clients. A search on the road of your vehicle is incomplete in the eyes of the law enforcement without the search of the body of the citizen. So when I was asked to say, what should you allow the police to search your vehicle? It's not going to stop there, because you could have come out with the offensive weapon, so that inextricably bound up with the searching of your motor vehicle is the search of your person. So we have another issue where the search of the person of a citizen is often conducted in the open and full view of the public. This is a breach of your right to privacy. I know it's hard on the police, but when I see police asking young men in particular to raise their arms and searching, taking out what's in their pockets in the full view of the public, this is a breach of your right to privacy. Consider the licensed firearm holder, for example, who does not wish anyone to know that he's armed, including the police, other occupants of his own motor car, and passing public, being searched and being exposed. Consider items of a very private and personal nature being taken from the pocket or pocketbook of an occupant of a car in the open view of the public. These are breaches of your right to privacy. There are just some examples of the fallout of our right not to be searched and our protected right to privacy being breached by agents of the state. At times, even when there's a reasonable cause for suspicion, the citizen is taken aside during the search of the vehicle with no opportunity to observe or prevent the planting of evidence. Let me repeat. Very often I see young men taken away from their vehicle whilst one police officer is searching the occupant, another is searching his vehicle without any sight or supervision of the person being searched. In the case of Harry Daly, which was an appeal 28 of 2010, there was a search done in the absence of the suspect. The court frowned upon searches done in the absence of suspects. And at paragraph 51, President of the Court of Appeal, Panton, as he then was, had this to say: Assistant Commissioner of Police Fellis did something else that was very strange. He said he had the house of the appellant, who was a suspect at the time, searched by the appellants in the appellant's absence, while the appellant was in the custody of the police at Horizon Park. So that the appellant was available to the police, but they went to his house and did a search. The average Jamaican citizen is totally up in arms, not literally, about the police going to your house and searching in your absence. The President went on to say, Mr. Fellis, that's the police, said he was not present at the search. All the items that were taken, he said, are documents. No one was present at this search on behalf of the appellant, nor was there a justice of the peace to observe the proceedings. Further, no list was made of documents that were removed. So we can see in the Harry Daly case what is required and what was not done. Firstly, a justice of the peace at least should be present during a search. If documents or items are removed, there must be a list given to the suspect. You know, there's a tendency in policing and in the minds of some citizens that once the police arrests you, you lose all your rights. May I come with you to search my house? Shut up, boy. That's a reality. I know that happens. I recall after Esha Miller was freed in his first case, and I was transporting him from prison, a police officer stopped me and asked for a search of my car. We came out, but I made sure to take the mats out firstly and told the police I didn't trust whether they would have slipped something under my car mat. That's such an unfortunate situation, but my experience teaches me that wisdom. Quite apart from the risk of planting, the police may take away material critical to a defendant's defense during a search and later deny that they have it. Sorry, police, the bad apples have caused me to be saying this. There is too an old call for body cameras, which have been resisted by many police officers. Why aren't body cameras being placed on the uniforms of police officers 10, 15 years after they have come into being? The fear could not be that cameras do not lie. Returning to the Heman's case, the judge dismissed the idea that Section 58 of the Road Traffic Act permitted the police to search a person's vehicle. And in fact, if you look at the judgment of Justice Batts in the Heman's case, he referred to another case which seems to have suggested that Section 58 of the Road Traffic Act permitted the police to search a person's vehicle. Now, this is interesting because even if the Road Traffic Act said that, without reasonable cause, the Constitution, being supreme, prohibits searches in the absence of reasonable suspicion. But Batts went on, Justice Batts went on to say, he went on to give his interpretation of the sections in 58 and its subsection, which he said empowered the police to redirect or divert traffic for some reasonable purpose. So let no one tell you that the Road Traffic Act allows the police to search your vehicles and also to search your documents. The police can only request documents and driver's license on a basis similar to which they exercise the power of search. That is, they entertain reasonable suspicion that a crime is committed or about to be committed. Now, this may seem a very radical position I'm taking, but it is supported by the Heman's case, it is supported by the Constitution, it is supported by Section 13 of the Jamaica Constabulary Force Act. reasonable suspicion is a prerequisite for search of documents, motor vehicle, or your person. We are not in a police state. We are in a state governed by the Constitution. So that Justice Batts gave some examples of reasonable cause. And he gave 4. Firstly, he said, it must relate to a peculiar characteristic of the person. And that doesn't mean because your pants is below your waist and you're of dark complexion and you have a kerchief around your head. It means that that is a peculiar characteristic why the police should be stopping you. Secondly, peculiar characteristics of the vehicle. And one can understand this. If my vehicle is stolen and I know it has a dent to the front fender, I'm able to tell the police my car is X make and it has a dent to the front fender. So where police sees a car fitting that description, then he would have had reasonable suspicion. Thirdly, the manner in which the vehicle is being operated, and that speaks for itself. If you're going down Half a Tree Road at 150 kilometers per hour, the police may wonder if you are a getaway vehicle. And lastly, Justice Batts said, the police is basing their reasonable suspicion on information received, and the police must be able to act on that. The police is called and given a certain description, or either the person or the motor vehicle, and they are acting on that information received by the police. Of course, we know as practicing lawyers, the police use that information received tag to carry out most of what they do. And as you know, you can't inquire in a court what the information is that the police received. So that's a loophole that I don't know how advocates very often are able to get around. So Section 13, subsection 9 of the Constitution suspends many of our rights during a state of emergency. And I couldn't have left out states of emergency because they've become the norm. A declared state of emergency allows the state to make laws and regulations during a state of emergency, which would otherwise be inconsistent with our liberty. The security forces are given wide powers with, for example, no recourse to habeas corpus. Or for non-lawyers, it means that if you're in custody and the police have kept you beyond 24 hours, you can go to a judge in the parish court and ask for the police to account for the reason you're being detained. During a state of emergency, our rights and liberty guaranteed by the Section 14 of the Charter are suspended. And this is why many lawyers are not happy with the continuing repeat of states of emergency, because our rights are sacrificed in the interest of public good, as they would wish to say. The powers of the security forces during a state of emergency, you will appreciate, is a topic for another presentation. I thank you for your attention, and I may have raised issues which you need clarifications on. I would endeavor to do. You may put your questions in a chat, in the chat room, and I'll try with my assistant to address those which I can. So thank you for your listening, and I couldn't have said much more because I had this narrow topic of search. Should you give the police permission to search your vehicle? I hope you have been edified now, and I hope that police officers have listened and are taking heed to the cautions that I've put, which are not my cautions. They are cautions that the Constitution has put in place for the citizens of Jamaica. Thank you. I'm looking out for your questions in the chat.
Thank you. We're going to move now to questions from the chat, from our audience, and we invite you now to put in any question that you may have.
Is it? Yeah. Seen any? Nobody interested.
What time is it now?
Okay, someone has asked, can I expand on the search on the Zozo conditions? Let me make it very clear at the beginning. The only law that can suspend the right not to be searched is the declaration of a state of emergency. So whatever you see in any Zozo provision, which does not require reasonable suspicion, is in my view unconstitutional. You can only suspend the right not to be searched by the declaration of a state of emergency, which can't go beyond 14 days unless it has the support of the opposition. So the answer to that is, whatever provision or whatever behavior you see being carried out during a Zozo operation or in a Zozo zone, it is, in the absence of reasonable suspicion, unconstitutional and can be challenged.
Officer, and he asked for a search.
Okay, so the question is, if I'm stopped by an officer and he asks me for a search, should I allow him to do so? There's an incident which went viral where a gentleman who was asked by the police for a search, he asked, on what basis are you searching my vehicle? So I'm coming out of the textbook now, I'm not on the road. You must use your own judgment of survival. Ask for a search. Officer, may I know the reason for your asking for this search? He's going to be offended, generally. And he's going to tell you, we're searching for drugs and arms. This is a general search for all the vehicles? Yes, sir. I'm afraid, sir, based on the law, I'm not able to give permission. No, you can't go any further because there's a force of arms that would come into play. But I would ask you to go on your phone and begin recording so that the judge can hear. You're asking for what the citizen asks, what is the reason, what suspicion you have while you're searching me. And if he's insisting, please do not get in a physical altercation with the police. Allow him to search and record that you protested, so that the pleadings will be beautifully recited in the particles of claim. I was requested for a search. I asked the reason for this search. I got no satisfactory reason which would support any that I was the subject of reasonable suspicion. And then you go collecting your award after. That's my answer.
The item found in a car.
Okay, that's a good question. So here it is, a search which commences being illegal. That means the police did not have any reasonable suspicion, but he comes upon an illegal firearm. Then we know how the law treats that. Unlike the United States, we do not have the fruits of the poison tree. That is, anything that comes from an illegal search is inadmissible. Unfortunately, the English law does not carry that provision. So it's converted to admissibility, and therefore that illegal thing found, although the search commenced without reasonable suspicion, becomes admissible in a criminal court. So you're not in the US, you have to keep it real, you're in English jurisdiction.
Another comes. Social media, there was a video in which
Okay, good question. I did see that video. When the police in that video, the person asked, was the police making an order or making a request? I think that that gentleman was very, very informed because he asked the police, are you making a request? What I think he was trying to say, do I have a choice? If it is a request, then we need a consent. The law knows that once you're making a request, you must get a consent. What the citizen wanted to know, is it an order? Because once it's an order, I'm going to comply, but I'm going to protest in comply, and I'm going to go to the civil courts. So that if it's an order, I will comply because the police is making an order. It's an illegal order, but I think that distinction is important for us when we're on the street to ask the officer, is this a request or is it an order? Because the latter invites more pecuniary visitation and damages. That's how I would look at it.
expound on the search on the.
I think I answered that. Yeah, the people are still troubled about Zozo or no Zozo. Only states of emergency can waive your constitutional rights and can take away. But even in the Constabulary Force Act, you must have reasonable suspicion. So let's put the Constitution aside and let's put Zozo in place. The police officer there is required by Section 13 of the Constabulary Force Act to only search where he has reasonable suspicion that a crime is or is likely to be committed. I wish some of the parliamentarians would be online to hear that when they're trying to pass laws which will circumvent existing laws or constitutional provisions, they should know that they are going to be challenged successfully.
Does the law say that the reason or cause for the reason? Is it enough for that to be communicated to the judge?
I think that the police has a duty, respectfully. The question is that the reason for this reasonable suspicion, should it be communicated to the citizen? It must be. I mean, I want to borrow a constitutional provision which says upon arrest, the person must be given the reason for his arrest within a reasonable time in a language that he understands. So that I would borrow that principle to say, once you're going to take away my rights not to be searched, I must be told the reason for taking away that right so that I can see whether I need to comply or not to. So the answer I would give to that is that the police should not keep the reasonable suspicion in his mind. He needs to tell the citizen the basis on which I am going to, as it were, take away your rights not to be searched. Did he say peculiarity, or I'm not sure those were the words used by Bert. If I could look at my notes, could someone tell me what that slide says? I'm not sure the judge said the peculiarity of the person's appearance. But Okay, so if a lady's handbag is grabbed by a gentleman who has a scar to his left cheek and his bleached complexion, and the police sees that person who is bleached and has a scar to the left cheek, then I would think that that person is the peculiarity of their appearance must be because it was described by someone who was wronged. So that if someone looks peculiar, and that's so subjective, that's not a reason for the police to be stopping you on the road. So, I mean, you know, peculiarity is sometimes as a result of disability. So I do not think that as a standalone peculiar appearance gives the justification for a search. That's my take on that. Okay. All right, so your questions have been interesting. I could take 3 more questions because I have to go elsewhere. 3 more, and I'm waiting on any other assistant? Not yet.
They're probably typing, so.
Okay, I'm taking 3 more. If there are 3 more, I'll take them. If there are no other questions, I'll wait another 2 minutes for your typing exercise to be completed, and then I will be through.
Okay, it appears that
I
there
think it's
are
slide 19. Is it slide 19? Yeah, what did he say about their parents in 19, the judge? I quoted him. Did. I gave 4 examples given by Justice Batts in Heman's case that could arouse reasonable suspicion. And there was one about their parents of the person. If someone can assist me, I got a slide 19. What is the first, what about the appearance of the person? Could you just remind me what Justice Batts said? Any other question whilst we look for what Justice Batts said about appearance? Is it online? May I just check my phone?
Yes.
The absence of any other question, maybe just take that one as the last one as I search for what was said by Justice Batts in terms of appearance, because we know as profiling by the police is not uncommon. And public health and safety checks. Yes, I know that, for example, during COVID, there were persons who were at large and the police were in search of them because they were transmitters. I think that if you look at the Constitution, it allows infectious diseases to be one of the considerations for the suspension of our rights. So I think that if there's a stop and search in the interest of public health, the police would be protected. That is a person who is 6 feet 4 inches tall, has escaped the quarantine and is at large, and persons fitting that description would be also stopped by the police. I could see that that is constitutionally accepted under the law. That's a good question. Okay, so in justice, so I'm now getting that it's the judge says relate a peculiar characteristic of the person. Okay, yes, Justice Bass did say it may be reasonable, a peculiar characteristic of the person. Now, those of us who practice in the criminal courts, whenever persons are describing their assailants, they would say the person had a big head like mine, and they had a scar over the left eyebrow. I think that is the peculiar appearance is related to a description given to the police, not that the person has a peculiarity in itself. The peculiar characteristics must be as a result of that description given by a person who made a report to the police. So I think that clears it up, because we do not want discrimination to be carried out against disabled persons and persons who are cross-dressers or bleached or whatever. We can't discriminate against the individual based on their peculiar characteristics, simpliciter. Thank you. That seems to be it.
One final question.
Last question. What is it?
Which body is responsible?
Oh, which body is responsible? Oh, there are several. I mean, firstly, Indicom, Parliament itself has created Indicom to carry out inspection and to deal with police officers' misconduct. But within the police force itself, there are disciplinary bodies set up. Office of the, I forget the name of it, but within the police force, there are bodies to deal with their misconduct. However, the criticism of that is that the police are watching themselves. And that is why, because the police came under that severe criticism, that Parliament set up Indicom to come and investigate. And remember that police officers are compellable when they are being investigated by Indicom. That is, they must give statements surrounding their behavior and their conduct. Thank you. This has been very helpful to me. I hope it has been helpful to you. And thanks. All the best to the law students who will be coming out to be attorneys soon. This is a hot topic. Jamaican citizens have to interface with the police, and you'll be getting a lot of complaints from your clients about police conduct, which you will have to measure against the Constitution, the Constabulary Force Act, and decisions such as Heman's, decisions such as Harry Daly, and others, as the courts seeks to protect us. Justice Batt's book on the Constitution and the law I recommend it, because the book has been very helpful in explaining in layman's language all rights under the Constitution and on laws and from questions often asked by citizens. All the best. Take care.
Thank you. Ms. Brathwaite is up.
Brathwaite is muted.
Thank you. And on behalf of all of the staff and students of the Norman Manley Law School Legal Aid Clinic, we want to thank our live audience and our presenter this morning, Mr. Bert Samuels, for having shared with us. And we look forward to seeing you at 11 o'clock, where we will begin our discussion on the Road Traffic Act. Thank you for tuning in.